Jon Corzine facing more legal woes, federal regulators are expected to file civil charges against the former MF Global CEO for his role in the collapse of the brokerage firm, MF Global. Kayla Tausche now with the story. Kayla.
Maria, nearly 2 years after brokerage MF Global declared bankruptcy, the legal battle facing former CEO Jon Corzine could be coming to a head. Sources say the CFTC is readying civil charges against Corzine, the firm's CEO, when it went belly up on the back of an ill-timed sovereign bet. As it entered bankruptcy, nearly $1 billion in customer funds went missing. They were later found at clearing banks and international affiliates, but the misplacement of those funds has been the focus of investigators. A spokesman for Corzine says, quote, during the difficult final week, Mr. Corzine was never informed, nor was he ever given reason to believe that customer funds were at risk or were being used improperly. If the CFTC brings this enforcement action, Mr. Corzine would welcome the opportunity to litigate this matter in an impartial venue. A majority of the CFTC's 5 commissioners must approve the charges. The New York Times says the agency has informed Corzine's lawyers there is no opportunity to settle. The CFTC had been working in concert with the Department of Justice on this case. The move to evaluate a separate civil case against Corzine by the CFTC is a departure from that and leaves unclear the status of the DOJ's review. Maria?
All right, Kayla, thanks very much. Tom Curran is partner with Pecker and Abramson, and Andrew Stoltmann is the securities attorney with the Stoltmann Law Offices. Good to see you, gentlemen. Thanks for joining us. Tom, why is this a civil case and not a criminal case? Is there a lack of clear-cut evidence?
Well, the line between civil and criminal is gray at best, and who's to say that it doesn't become a criminal case? The DOJ hasn't made any announcements, or no one's made any representations about that. And we saw with the Stanford case where the SEC action actually preceded the criminal action, although unusual, it does happen. Basically, you try to evaluate as a regulator, civil and criminal, the conduct, the results of the conduct, the extent to which duties, like fiduciary duties, were violated. Were they violated directly or indirectly through a failure to supervise or what have you, in trying to determine from all the factors where on that very vague line does this fall in terms of civil as opposed to criminal.
So, Andrew, the CFTC said it won't settle with Corzine. Why such a hardline stance?
Well, for a long time, the CFTC has been known as kind of the 98-pound regulator. They haven't been known for being all that ferocious, and I think they want to change their reputation. I think they also want to send a clear message to other CEOs at firms like this that, guess what, even if you didn't personally know about the conduct that's at issue, as a control person, we're still going to hold you liable. We're going to come after you hard, and guess what? We're not going to let you settle this case with nothing more than a slap on the wrist. We're going to make it public. We're going to prosecute it, and we're going to push it really, really hard.
And that's something of a departure, frankly. For government lawyers to, when approached about a settlement, for them to refuse to even engage in settlement discussions is a great departure, although an increasing one that we see with civil regulators like the SEC these days. They just out and out refuse to discuss settlement, which makes them different than every civil litigant in the whole wide world.
But wasn't there, I remember, Terry Duffy from the CME came on and talked about what he heard, and there was conversation that someone underneath Corzine said, we need to take the money, get the money, and he said, do whatever it takes. So is that the argument, that he had no idea what was going on?
Well, yeah, Maria, I think that is his argument. I think his position is going to be, hey, look, I didn't know about any of this activity going on.
Even though he said, do what it takes.
Well, perversely, he actually has to say that he was an ineffective, uninvolved, disengaged manager, and the people underneath him did certain things that he didn't know about, which isn't exactly a defense that makes him look good.
Is that believable?
No, it's not. It's not believable, because when you are the CEO or the partial owner of a firm, you have to know what's going on. You can't bury your head in the sand. And this is primarily a failure to supervise claim in addition to a control person liability. And I think Mr. Corzine is going to have real problems saying, gee, I was just the CEO. I didn't know anything that was going on. That's going to be tough.
And it'll be interesting to see whether any of the people underneath him, who he says he didn't know what they were doing, if they're also defendants in this, the part of their defense might actually be, well, he sure did know because I told him.
Well, if you're facing a squeeze and you don't have the money, and you know that the money that you could have access to is only customer money, I mean, can you really say I didn't know where the money was? You're facing a squeeze. No. You need the money. I mean, so.
Of course, and Maria, also there's evidence, at least in a private lawsuit against the firm, that Mr. Corzine was told a year before this looting, if you will, took place, that, hey, look, there are problems with the internal controls. Now, I don't know if that's true. I don't know if it's accurate, but the allegation is out there. If those sorts of things are discovered by the CFTC and Discovery, I think Mr. Corzine's going to have a real problem defending.
There are a lot of ifs there. Let's try to have some responsibility. There were a lot of ifs in that sentence.
Right. But so if and when this suit comes forward, what's Corzine's best defense here?
I think what apparently his defense has been all along, which is that he did not know that customer monies were used improperly, or that they were improperly at risk, or that they were funding firm operations in a way that they ought not have. And that if that had been done, had he known that he wouldn't have allowed that to happen.
But
and therefore, and he's going to, it's a tough defense in a civil case, because at the end of the day, it really doesn't matter. In a criminal case, it really does matter, though.
All right, gentlemen, thank you very much.